Hi, this is Attorney Jacob Sapochnik. And I wanted to thank you for watching our video. I wanted to briefly discuss the major factors that clients are facing or they need to know when preparing an I-601 waiver. As you know, there's been proposed changes to the 601 hardship waiver, and there's going to be new forms, the I-601A. I just wanted to touch base quickly on the factors that clients need to know. What are the main points that you need when preparing a waiver? Well, basically the waiver is hardship to the U.S. citizen spouse. So this is the main point that people have to realize, that the qualifying relative as a spouse is very important. And the hardship is not based to the immigrant that is currently out of the country or about to leave, but it's actually to the U.S. citizen. And this is a major misconception people are having those waivers. So the U.S. government are looking at a few factors. First of all, they're looking at medical factors. So if the U.S. citizen spouse has any condition that will require her to be in the U.S. to get treatment, or will not be able to get the same treatment in the home country of the immigrant, those are factors that we need to emphasize when we're preparing a waiver. The second thing that we use in a waiver application, I'm looking at educational factors. Is the U.S. citizen spouse going to school or about to go to school, taking a loan in the middle of a course, leaving that or breaking that education opportunity is going to result in extreme hardship because they're not going to be able to continue that in the home country. The third factor that we're looking at is financial. Whether the U.S. citizen spouse has a business, or about to start a business, or helping another family member in the business, or they are contributing to the family financial pool, and if they're leaving or they're going to have to leave the U.S., that's going to result in extreme hardship. It is important to emphasize and structure that particular factor carefully, because this is really going to be a strong element of the case. Another factor are special considerations. Is there a particular scenario that we want to show that this particular U.S. citizen is going to suffer, either at work, or because they're going to be promoted, or because they're going to be applying for a particular position, or because they're helping another family member that is ill. So these are particular special considerations that are different for every case, and we would like to emphasize that in the particular scenario. And finally, we're looking at the country conditions. Is the country that the U.S. citizen spouse about to go is dangerous, or lack of employment, or language barriers, or anything that we can show that if that U.S. citizen spouse will need to depart, it's going to be virtually impossible for them to assimilate in that country. So those factors are important. If we can combine them or play with them to create a strong waiver, this is really where the U.S. government is looking to see whether the client met the standard of extreme hardship or not. As far as documents that we're looking at, usually if we go with a medical, we get affidavits, medical records from the physicians. If clients are suffering from mental conditions, depression or anxiety, we like to get continuing treatment. It's not enough just to get one document or statement from a psychiatrist. Many clients are doing that already, and so the consular officers are saying, well, if this is another document from a psychologist, how different it is from another case. We want to show that the client actually needs mental health treatment. We want to show the client actually is ongoing treatment, something that they won't be able to get in the home country. Other documents, strong affidavits. It's very important to have a strong personal statement to determine how the hardship is impacting the U.S. citizen spouse. It's not just enough to provide a document that is kind of an explanation about how they're suffering. Everybody's suffering. We want to show something unique and different in the individual case, and that's where the attorney is working with the client to really bring out the story. So all in all, the new waiver provisions have not changed the hardship definition, except that now it's very important to, if the new changes are going to pass, it's very important to document and collect all this evidence in preparation for the in-country waiver and special factors that are unique to that particular client's case. All the best and success in your hardship waiver case, and if you have any questions, feel free to email us at any time. Thank you for watching, and I look forward to providing the next video.